Welcome everyone, this is Tim Pullman and you're listening to the SEP Couch. This podcast is all about standard essential patents. We talk about patent strategies, friend licensing, patent pooling, and patent litigation. So let's dive into today's episode. SEP litigation is not national, it is international. And I'm super happy today to shed some light on a market that is more important than I think many people believe. It's the Brazilian market. And who else should I talk to than the go-to law firm in Brazil for SEP matters, which is Licks Legal. So I'm more than happy that I have here today Rob Rodrigues and Otto Licks, partner at Licks Legal. Thank you for coming to my podcast. Hello, guys.
Thank you. Pleasure.
Hi, Tim. Pleasure to be here.
I am more than glad to have you here and to hear more about, the law in Brazil and SEP matters. But before we start, I would love to hear a little bit background on how you guys came to the topic of SEPs. When was that? Give us a little bit of a time travel here. And maybe Otto, you can start this off, please, and then give me some insights on, how you got in touch with the topic and what were your first cases?
Well, it goes back a long time ago. I have started my career in policy making of patents, working for the Brazilian government at the WTO TRIPS agreement final stage and in the implementation of the current Brazilian patent statute. I joined private practice in the late 90s, where I started with pharma and agrochemical patent litigation. Pharma, both human and veterinary. At that time, just like Mexico with NAFTA and China and Korea, Brazil gave transitional patents for life science, and that became the number one patent litigation projects in different countries, and Brazil was no exception. Specifically on telecom, I have started litigating CCITT switching and signaling over Ericsson's MFC and System 7 and deployment of ISDNs. And our first project that resembles what we now call SEPs was for Philips and Sony's Orange Book patents on recordable compact discs and rewritable compact discs, the CDRs and the CDRW. Unfortunately, most of the patent judges nowadays don't even recognize one of those medias. But there was a big time litigation in Brazil. We were able to seize millions and millions of units. Part of my background was also the opportunity to litigate the project in Brazil around calling line identification presentation, the clip function. Most people will know the clip function by a US trademark made famous by AT&T called Caller ID. That was the largest ever litigation project in Brazil to this date. So our current SEP practice that goes back 11 years, and our first case being Ericsson against TCL, actually builds on an experience that started last century, and nowadays that has a wonderful group of patent litigators. I'm really proud to have Rob and several other lawyers and colleagues as members of this group.
Great, very exciting. And I wasn't aware that, litigation in Brazil has such a long history also on the topics of SEPs. That is very interesting. Rob, also tell me, how did you get in touch with SEPs and when was that?
Was not as long as Otto, but many years ago, I was, I'd say, lucky. We started the firm, and one of the very first few cases that we had the opportunity to file was an SEP case, right? So at that time, when the firm was much smaller, everyone needs to do anything. So you couldn't pick what you should do or not. So I worked with Otto in this Ericsson TCL case, and 10 years later, we're doing a lot of more cases. So yeah, it's a fun experience.
Interesting. How big is Licks Legal now, and what are your typical cases? And when you separate it by industry and topic.
Well, I think we are over 300 people. We are in different cities in Brazil and in Tokyo, where our Tokyo office just made the 10th year anniversary. We're going to have, in fact, a party in the upcoming months to celebrate that. And as far as practice, in addition to what we do to the telecom and ICT industries, we have very large and recognized practice in pharma and biotech, in agricultural seeds. We represent several of the Brazilian top inventors, and we have a regulatory practice that's fairly big. We do a lot of regulatory, not only patent litigation. And Rob, help me here. What else?
I think in Brazil, we're probably the largest telecom group, both in technical. We do have, is a little bit different from the US. So most lawyers don't have a technical background. So we rely a lot on hiring technical people. So they are full-time in the firm with us. Probably right now, one of the largest groups we have together with the life science group, probably 20, 25 people with different background, PhDs in different areas, from computer science to regular telecom. And we lawyers, we are not just lawyers, so we rely a lot on the expertise that they bring to the table to be able to build this successful practice.
Yeah, and I think that's also for me always was the exciting part, that patent law brings together the technical expertise, the legal expertise. I'm an economist, sometimes even the economic expertise in this world. So very different disciplines that discuss and understand, or try to understand, each other's worlds. And it is astonishing. Brazil is a very important country venue for SEP litigation. Can you tell us a little bit why that is? I think broadly people understand that getting a preliminary injunction in Brazil, there's some advantage to that. But what are the main reasons? Why is Brazil an attractive jurisdiction to litigate SEPs in?
Well, Jim, I think first because of the size of the market. Brazil is usually fifth in the size when you look into smartphones. It has a lot of users on the different platforms for OTT technologies, for streaming. Brazil is a big market. Brazilians like to consume a lot of the products and services that rely on standard essential patents. Second reason is that in this Brazilian market, the markup, the profits are usually very good. When you look, Brazilian consumers are willing to pay a premium for products that embed new technologies. When, regardless of the year or the specific model, usually the top models of smartphones will cost from 50 to 100% more in Brazil when compared to other markets. So it is a big and profitable business for several of the companies in these industries. That's, I think, is the number one reason why our clients seek our assistance when they face unwilling licensees practicing holdout.
Interesting. If you think about the products subject to SEPs, I think, of course, smartphones is always number one. Have there been any other products you have been litigating on so far?
Oh, sure. Tablets, notebooks, desktop computers, infrastructure, RBUs, what you could call generally, radio station, broadband, Wi-Fi.
So everything. And how about the automotive world? Has that arrived in Brazil yet? Litigation on that?
Not yet, but unfortunately, I can't comment much on that today.
That's good. Okay, so we're waiting for the first SEP automotive case in Brazil. Very exciting. In terms of the legal environment, so I understand Brazil is a huge market, and of course, any action in a market, especially when you are targeting a preliminary injunction, only has power when you can stop someone selling or making revenue. But how do you think, if you compare the legal system in Brazil, let's say, to the US or European system, what advantages you see here for, I think, especially patent holders, to litigate? Or what is your thought on that?
Well, I'm going to ask Rob to get into the more specifics, but I'll just introduce the topic to him with a more broader view. First of all, Brazil is a safe jurisdiction. And what do I mean by safe? Well, first of all, our killing rate is very low. So just to give you the example, in the last 11 years, with 25 projects, we never had a single patent killed.
So it's about killing patents, not people,
yeah.
Right?
So yeah, it's a safe jurisdiction. It is a safe jurisdiction. You won't lose your patent portfolio here. That's number one. Number two, Brazilian judges will not look into or entertain requests to establish standard essential patent rulings to the world or royalties to the world, or will not issue anti-suit or anti-litigation injunctions to other jurisdictions. It is a confined jurisdiction that understand its importance, but does not seek to outreach the limits of the Brazilian rule of law and the territoriality of the Brazilian patents. That's number two. So it is a safe system, but we follow a bifurcated system, more or less like Germany. We don't have a lot of stays, and in our litigation, we have the availability of having preliminary injunctions. But Rob can be more specific on those issues.
Yeah, I think one of core things also, we don't have a discovery system. So it's faster. You can go to a permanent injunction trial faster than other jurisdictions in comparison. If you have a good case, for instance. So we know that in SEP we focus a lot on preliminary injunctions, but outside of the SEP world, we do have several good bench trial decisions in a fast way, which is very can bring a lot of attention to the system as well. And the fact that we don't have any type of like eBay standard, for instance. So preliminary injunctions it is possible to get one. I think mostly all the infringement cases filed, they do have a request for a PI. So those matters makes a lot of attraction for Brazil as a main jurisdiction in Latin America and in the world. So that's why we see cases filing, growing in number of different technologies and other companies as well. So in the beginning, we saw more Chinese companies getting sued, but now we see European and American companies too. So I think that's it's definitely becoming a good forum to litigate cases.
And maybe can you also elaborate a little bit more, explaining the differences and the parallel procedures? We have that in Germany too, but I think not everyone is familiar. It's about, of course, always two topics. Is it infringed or essential, or is it valid? So invalidity. And in Germany, sometimes there are two courts. I mean, there are two courts, but sometimes the invalidity or case, takes longer than the infringement case. There's already a preliminary injunction, and etc. And some people criticize that a patent may be found invalid after all, but then there has already been, that preliminary injunction. How does that work in Brazil, especially when you say it's a safe harbor? Typically, they're not even invalidated.
Yeah, well, in our bifurcated system, the Brazilian PTO is a mandatory member on the invalidity proceeding. In addition to that, the Brazilian PTO has a post-grant opposition system to allow parties to seek to kill an issued patent at the office and not in litigation. The fact that the killing rate at the Brazilian PTO is very low, and that the killing rate at courts are very low, make it very difficult to have a stay on the infringement case. The courts that deal with the invalidity understand that the review of the Brazilian PTO actually happens during examination. Right. And when the Brazilian PTO issues the patent, it usually issues a patent that will not be killed. It helps that sometimes you don't get overbroad claims in Brazil that you might get in other jurisdictions. It helps that when you compare decisions of the Brazilian PTO with IP5, you see that they are very much aligned. So the patents that we take to court, they were granted and maintained in the IP5 countries as well. So we ended up with a very low killing rate. That teaches courts that it is unfair to stay the infringement, because at the end, every single defendant on a patent infringement case will seek an invalidity defense. But when you look at the numbers, they hardly ever prevail. They hardly ever prevail. So for this reason, it is very rare to obtain a success in an invalidity proceeding, and it's very rare to obtain a stay of the infringement because of the validity challenge. Again, if we can use the 24 SEP ICT cases that we have in the last 11 years, we had one case that was a stay during 3 months, and then the invalidity court system realized that the patent owner would probably prevail and allow the infringement to go on. So in 24 cases in the last 11 years, we had one stay for 90 days.
Interesting. And what is the tip? If you think about, you say, Rob, you said it's typically very fast also. Can you elaborate on this? From your experience, from your 24 cases, I think every case is different, but what do you mean by fast in comparison maybe to other jurisdictions?
Tim, thank you for the question. Are you aware with the Nokia and Oppo case?
Right, yeah.
Yeah, we filed a case in Brazil recently on behalf of Nokia. Preliminary injunction was granted in 26 hours.
That sounds good. Very efficient. What do you think? I mean, typically, licensing is global, and often litigation is global. And I think you mentioned in some of the pre-sessions we had to this podcast that, also large litigation cases like Ericsson, Apple, that the Brazilian decision had influence on the final settlement, right? How often do you think that is the case? How much of an impact does that Brazilian jurisdiction have beyond Brazil? Because of course, solving a case in Brazil triggers an agreement typically, right?
Tim, it does have an influence because the availability of the preliminary injunction requires the parties to litigate very fast.
Yeah.
You don't get a preliminary injunction in Brazil just because you docket a patent infringement brief. You have to reason with the court, and you have to show to the court that you have likelihood to prevail, that you're not filing an ambush litigation. You have to show the history of the attempts trying to license the technology. So all this ended up fast forwarding several of the issues that you could see years down the road in a trial before a jury in other jurisdictions, or in Europe once the stay for the invalidity is over and the infringement case is allowed to proceed.
Yeah, no, that makes a lot of sense. And please go ahead.
We have a second issue, which is in different cases, the Brazilian magistrates will, against what we've been asking the court, they will allow the infringer to be in the market, requesting the infringer to deposit money in a scroll account to the court. So different when you compare to to Europe, where the patent owner needs to post a bond if you want to enforce an injunction. Here is the opposite. The infringer needs to collect the money with the court if they want to keep infringing. And usually that amount is few times higher than the standard essential royalty sought by the patent owner. So at that time, usually we're able to settle. To give you an example, in every single standard essential patent that we had to this date, parties settled after the preliminary injunction. We don't have a single ruling on the merits at the end of a case because no case got to the end. We obtained the preliminary injunctions, parties settle. Settlement is always global. Our clients always seek a global license agreement. It's never about Brazil. Brazil assists in leveraging the global license.
And also, I think to my knowledge, there has never been a friend determination in Brazil either, right?
No, because we are very specific in not asking the court for that. Those, as you have mentioned in the beginning, those are global licenses. Those global licenses, they never elect Brazilian law. Those global licenses, when they have a clause on choice of forum, they never established Brazilian courts as the courts to litigate issues arising out of those licenses. So the Brazilian judges understand that those are not Brazilian license under Brazilian law that could be litigated before Brazilian courts.
Understood. But still the parties have to disclose that there's some licensing negotiation ongoing.
Oh, yes.
Global basis.
There is no ambush preliminary injunction in Brazil. If we don't show to the Brazilian courts how frustrated our clients are with years of attempts trying to license, there is no possibility of seeking a preliminary injunction.
Okay, very interesting. And if you think about years, I'm always interested to hear some numbers, even if it's maybe not representative and anecdotal evidence, but your typical clients, you know, after how many, you call it frustration, after how many years of frustrations do they typically approach you and tell you, hey, we're negotiating this global FRAND license. We're not getting anywhere. You know, we're now applying some more pressure. What is the sweet spot here?
It's if we look into the numbers, I would tell you that it's usually after 2 years.
Okay.
Okay. So most of our clients will seek to license for a bit over 2 years before looking into litigating in Brazil.
And have they typically litigated in other jurisdictions before, or is that then a whole?
Yes, we have in the beginning, our clients would already have litigation going on in the US and Europe, and sometimes in Asia. Nowadays, our clients coordinate and we talk to establish a better strategy for the adjudication campaign. So where do you file first? Where do you seek preliminary injunction, where you do not? And this is very important. It is a global business. It is a global license, but the litigation system, it's national. And we have to make sure that we work well with the client and with the service providers and the firms that the client uses in different jurisdictions. Usually success is very much tied up to the ability of having good communications with the client and with the other firms that are doing the same projects in other jurisdictions.
So basically you coordinate with the law firms in the US and Europe to have that global litigation coordinated.
Yes.
That is interesting. That's interesting here. When you exchange, experiences with these lawyers from other jurisdictions, do you compare systems? Maybe here a question to you, Rob, and differences. And do you see any, things that you discuss over dinner or calls, like which makes life easier in Brazil or the other way around?
Yeah, sure. I think right now the number one question is the difference of treatment for non-practicing entities in between those jurisdictions. So it's something that you can see a lot of difference if you compare US, Brazil, Europe, and China, for instance. So usually we see a number of new clients filing cases in Brazil, and they are non-practicing entities because our system doesn't make any difference, right? So the judges will treat practicing entities and NPs as the same, and that's a fair value also that Brazil is bringing to the table. We also in a position several times to for some US clients to tell them where they could file case in Europe, right? Everyone is now expecting the UPC. We don't know where it goes. It's a big topic, but often the clients are opting also to file in Germany and Holland. So we see these cases being filed here in Brazil and right together with the US, and after that in Europe. So it's a change in the last 2 years, I would say, with the pandemic. Brazil used to be the second wave, and now we see that as a first wave for some clients, which is very interesting. And that's where we compare those jurisdictions on those calls as well.
Is there any disadvantage with the Brazilian jurisdiction from a patent owner's perspective?
I think there's some balance. I guess it's not a dead end. So there are ways for defendants to protect themselves. So it's not like a case, okay, if I have a case filed and there are ways to stay PIs. I wouldn't call it disadvantage, but we try to have a due process here. Since we don't have a discovery, the judges will care about both sides. So you're going to have your day in court. So that's fair for both plaintiffs and defendants as well. So sometimes we have judges changing its opinion and then they change back. It's a very dynamic system where we have to improve a lot. Every case is harder than the other one. So we keep improving our knowledge. So that's important. So I'd say it's a very fair game and with pros and cons.
That makes sense. But still, as much as I learned from your cases, your success rate was pretty high, right? I mean, however you measure success, I learned, of course, a settlement is one, or a preliminary injunction that triggers that. But if you would think about your own success rate, it looks like the patent owners have a good likelihood, if they have valid and essential patents, to get their rights, right?
I think, to be fair here, and then I'm gonna give Otto a lot of credit on that. I think success rate is also the ability of our law firm to win the cases. So not as the system is just perfect, but I think we all together knows how to put together a good strategy to win cases. So I think Otto has a lot of like that, and that's why the success rate is so high.
That's glad to hear, Otto. But in general, of course, those, making it easier to get these preliminary injunctions and not, having a high likelihood of your patent getting invalidated is, in a way, can be considered quite, favorable for the patent owners. At least, from a broader point of view. What I've always found also interesting, especially also when we talk about invalidity, I mean, standards are written in English language. When I look at our clients, most do claim charting on English original patents, mostly US and EP patents. Does language actually play a role? I think your technical experts, I guess, speak Portuguese then, and they look into English written standards. How does that, is language, does it play a role, or or you think it doesn't even matter?
Rob, I don't know how you would see this in any particular case, but in general, Tim, people involved in technology understands that English is one of the language that you use to communicate. So it's not that the experts will use English to work in our standard essential patent cases. We use experts that have several publications in English, that have published chapters in books in English, that travel abroad to give speeches in technical and scientific conferences in English. And when we look into the patent courts, that's the everyday of those judges, clerks, and experts, regardless if it's standard essential patent, if it's a biotech case, if it's an agrochemical case. English is a very important language to share technical information in the world.
Yeah, we just have an expert that been working with us forever, and he is, I think he was nominated, I don't know if he's still in the endorsement phase, for IEEE fellow. So most of our experts, they have a very international background, so they understand the whole package, and they know how to apply that to Brazil specific. So yeah.
But I was also referring to that the claims are drafted in Portuguese, and charting a Portuguese claim to an English standard as a claim chart, or identifying prior art. I was just wondering, is there anything that language may make a difference here, or is that the same?
I would say not really. And that's, again, just like an agrochemical case, just like a biotech case, and just like any other case. And the exercise for infringement is a different one when you compare one invalidity project, but the relationship with the language is the same. By the way, when we have cases purely in Portuguese with a first filing in Brazil, no claim of priority, against a piece of prior art in Portuguese as well, people will debate the meaning of specific words in Portuguese. So you don't escape that. Lawyers will try to test every single opportunity on behalf of the best interest of their clients. And every now and then, we do have to debate and to file motions and briefs and evidence on the meaning of Brazilian words and Brazilian text. So years down the road, after someone wrote a claim or wrote the specs or wrote a piece of an article that is prior art, when everybody will look into that 5-10 years down the road, that will invite different opinions and different interpretations, regardless if you're using two different languages or the very same one.
Okay, I was just wondering, maybe it adds some complexity to it, and you know, translation and those kind of things. But very interesting.
We take that for granted. We so use it to that. I guess that's we don't see that as complexity, but maybe for people that don't have they're not used to that system to. Yeah. I think most people here study outside, so I think it's just a matter of like. So maybe we just take that for granted.
Yeah, what we see, Tim, is it's not, again, particular to a language, but when comparing patent documents, claims, with non-patent documents, we usually have a harder task because of the difference in the level of abstraction and details of the different documents. So sometimes comparing a claim of an issued patent with prior art that are also patent documents, filings or issued patents, it's easier than comparing to the language of the standards or a technical article because of the difference in the level of abstraction, the in-depth, and the scope of those different pieces.
Yeah. I mean, I just saw some PTAB statistics, and it shows also in our data at IPlytics that more of the prior art is actually in the standardization document world, you know, publicly available contribution documents and minutes that are, you know, that invalidate those patents than other patents. And these are always in English. So I was wondering if there's any effect on that. But I think you are also in the business of prosecution, and understanding now that Brazil as a jurisdiction in litigation becomes more important, I could see that it may also trigger companies to file more patents in Brazil, especially in the telecommunications space. Do you see any trends there? And you're also helping clients to file essential and valid patents in Brazil?
Well, Tim, certainly one of the few things that we cannot add value is when a client realizes that he or she should have filed a portfolio in Brazil 10 years ago. That's tough. But I think in the last few years, Rob has done a terrific job in preaching the gospel and showing that Brazil is a relevant jurisdiction and it's a relevant country where the patents that the applications you file will mature into valid patents that can be used to make sure that the exclusivity is enjoyed.
Yeah, I think we're the first firm in Brazil to really see a patent as an asset. So patent application is something that you need good claims granted to use it later. Most of the firms in Brazil, they use it, they didn't say it that way. So a lot of clients, not just owners of SEP, but in other areas, are now using us to file their cases, to help them select the case that they should file in Brazil because of that expertise that they know they're gonna need later on litigation. So I think the fact that we have this large experience in litigation is helping a lot clients when they want prosecution.
That makes sense, because you can basically also file a patent with thinking about a potential, you know, invalidity check or essentiality, claim charting, you know, because you want to commercialize that patents down the road, right?
And even more like for local clients now, Brazilian clients now, the idea of selling assets in the future. So we see that as a new thing that we didn't talk before. So 15 years ago, you wouldn't have many Brazilian companies, Brazilian universities filing patent applications, thinking of in the future I might be able to sell that and that be or getting royalties out of that. So we're changing a lot the dynamic of the IP market because of that experience as well.
No, that's interesting to hear. Actually, I have to admit, I feel in the German industry, it's a very, very similar learning. Most of the small, medium-sized companies, in particular in Germany, have not filed. Even the big ones have been very using the patent system as a defensive, system to just make sure, you kind of like patent your way and secure your market, but they wouldn't sell or license or even, especially not enforce those patents against any of their competitors. And now understanding patents are an asset is I think an important step forward to understanding how to make business out of licensing and selling those patents.
Yeah, that's true. How to make business out of IP is something that we see is a change. It's I think with the SEP cases, this is also the environment becoming more and more business as well.
Yeah, I think SEPs are always a good example of understanding how lucrative a licensing deal can be. There's a lot of experience in licensing out there. And it will go beyond the traditional industry. So I'm excited to see maybe also some other new cases picking up. Maybe also beyond the smartphone computer world, automotive is up and running, but also we see first cases in the IoT now popping up. So that is, I think, exciting as well, because connectivity is everywhere. Standards will be implemented much wider, and that will probably also be the case in Brazil, I guess.
Certainly, we already seen a lot of interest in that in the agro business and the protein business. Brazil has some huge farms and facilities that export soybeans and proteins throughout the world, and IoT is definitely playing an important role in helping the Brazilian farmers to increase the output. Brazil is a big country, but it's not getting bigger. The land is the land that we have, and making sure that we can produce always more within the same limits that we have, it's very important for that industry. And IoT is over there to add value too.
That's interesting. Yeah, exciting to see first cases popping up. If you think about the past 12 years of SEP litigation, is there any general trends that you can see? What has been, what has changed since 12 years ago? Is it different clients? Is it different decision making? Is it that the whole system became much more professional? Any trends you have in mind?
A trend, and I think Rob will have a lot to add to that, but one trend that I see is the impact that the specialization and the sophistication of the judges have in the outcome. We have in Brazil specialized judges for both the invalidity and for infringement, and in the courts in the state of Rio, we have the judges that deal with infringement also hearing bankruptcy and company restructuring. It's not only patent infringement. That have showed a huge positive effect, because those judges understand very well the cost of money, the needs for cash flow, the importance of obtaining running royalties to fund the next generation of products and service. So it's not about a pot of money at the end of many years of litigation. It's making sure that the patent owner can recuperate now in order to keep up in the business, not to lose the ability to be one of the top providers on the technology.
No, that's interesting. So understanding the market and how the market functions better, right? Like,
oh yeah. So
businesses.
I can give you an example, Jimmy. Here if you are an unwilling licensee, and if you try to tell the judge in Brazil that it's taking you 3 years to decide whether or not you're going to pay the royalties, that usually does not fly with a Brazilian judge, especially when you have Brazil as one country that has a very high interest rate, one of the highest in the world. So the judges understand that this is not reasonable. For a product that sometimes is 8 months in the market, not even a year, taking 3 years to decide whether or not you're paying the royalties will not fly as a defense here.
Interesting.
Yeah. And I think it's an international trend. When me and Otto had meetings 6-7 years ago, or even going to conference, everyone was like, okay, why Brazil? And nowadays everyone is asks for meeting with us and see, I have this asset there, what do you think? What about those targets? What about those companies? So I think it's changing a lot. We see more people sending us email, requesting meetings. They want to understand, and before that, we were trying to chase the opportunities and see. I think there's an interesting change as well to comment. And I think others we comment during the call as well. I think not just several new companies are seeking filing case in Brazil. So we don't see the same companies. We see more and more different. Yes, if you are a potential defendant, you're probably gonna have a case file against yourself. So that's a trend that I can say.
Great. Very good. Some very great insights from both of you, Rob and Otto. Thank you very much for the great conversation. And what I always do at the end of the podcast, I'll give you a final statement. And today, each of you, by the way, you are the first double interview here I ever had. So what do you want our audience to remember in, let's say, 3-4 sentences? I'll start with you, Rob.
Yeah, I think I would like first to be very grateful. I think the clients, everyone that file and believe in Brazil, it's important. I guess we improving a lot the system and the fact that we do have, for instance, preliminary injunctions is what comes to the mind. But also, Brazil is a developing country with more opportunities. And soon we're gonna see more and more cases filed outside of SEPs as well. So and thank you very much also for this opportunity and this podcast. I really appreciate the opportunity.
You're very welcome, Rob. Thank you. SEP and the law in Brazil. Otto, your final remarks.
Oh, Tim. Brazil is a good market, and the Brazilian legal system has shown for over 10 years to be constantly in the side of innovation and to support the innovators that seek to file patents and obtain protection in Brazil. Enforcement of those patents have constantly been upheld. We have a series of good results. It's not about 1 or 2 cases, not about what happened in 2022 or 21. We're talking about over 10 years of standard essential patent litigation. And we constantly see a positive outcome. As Rob, I think, mentioned, it's not getting easier, unfortunately, it's getting harder, not because of the willingness of the Brazilian legal system to issue and enforce the patents, but because of the unwilling licensees that invest always more and more to seek to delay or to avoid paying for the use of technology developed by third parties. So it is a never lame duck. it's always a cat and mouse game. But so far, the companies investing in technology and seeking the protection of the Brazilian legal system, I think have seen and obtained positive results.
Great. Yeah, if it was easy, it would be boring, I guess. But thank you so much, guys. Rob Rodrigues, Otto Licks, both with Licks Legal. Thanks for listening in today, and I hear you at the next episode. Goodbye.